Celebrity estates are just messy. This is going to be an all-out war. The sons of the late Queen of Soul aren't showing any respect for their mother's last wishes. A trial in probate court starts today to battle it out over her estate. Three of Aretha Franklin's four sons have conflicting views on how to divide her assets as well as her money. 8 months after her death in 2018, the family found, get this, handwritten wills in a notebook hidden in her home, tucked inside of a sofa cushion. Now, Franklin didn't leave behind any formal typed out instructions for her money, her property, really leaving behind a legacy of mess and confusion for her family. Let's bring in Danielle Mayoras, an attorney who specializes in estate planning. Danielle, thanks for hopping on the show.
Thanks for having me.
So, Danielle, you and your husband are also the authors of Trial and Errors, which is a book about highly publicized estate battles. This trial starts today. I also understand your husband consulted on this case early on. How does this compare to other celebrity estate fights that we have seen play out before?
I think this is pretty typical in the fact we've seen a lot of celebrities not do any estate planning. Now, it's to be determined if Aretha Franklin did estate planning or not, but surely nothing was signed and executed with an attorney before she passed away.
And speaking of that, some of these details here, like, it's almost like it's out of a movie, right? She had these handwritten wills stuffed inside couch cushions. What exactly will the court be deciding here in this case?
Well, there's two handwritten documents that the court's going to be looking at. One is from 2010, one's from 2014. And as you said, the 2014 was in a spiral notebook stuffed under a couch cushion. The other was in a locked drawer. The court's going to be deciding if one of these documents is actually a valid will in the state of Michigan. And there's a couple different ways that can happen. One is we do recognize holographic wills in Michigan, but there's also an exception. So if she put something in writing intending it to be a will, and the judge decides, or the jury decides in this case by clear and convincing evidence it is a will, then it will also stand.
Okay, and when you say holographic will, you mean handwritten, right? I think a lot of people might not be familiar with that term. Which one do you think is going to hold legitimacy, and how will we be sure how her mental state at the time, will that come into play at all, and how do we know what it was when she wrote these to begin with?
That's a great question. It's important that she actually had the intent to write a will, and that's one of the things that the court needs to look at when determining if either of these documents are valid. For a holographic will to be valid in Michigan, it needs to be in writing, it needs to be signed, and there needs to be the intent to do a will. Now, the 2010 will that's at issue, or the alleged will, is definitely signed by Franklin, but it's questionable if the 2014 one is or not. So it will be interesting. When you look at these wills, it really blows the mind. I mean, you see things crossed out, you see blanks, there's even a notation on the 2014 will to fill in later.
It's scribbled, yeah, and that's what I mean. It's like out of a Hollywood film. You can't make this stuff up, and her estate worth about $80 million, I believe, so this is going to be an all-out war from her family. Danielle Mayoras, thank you so much.
Thank you for watching. Go to newsnationnow.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.